Hello, everyone. My name is Tim. You're watching Lost in Law. Today, we're going to be talking about the concept of willful blindness. Willful blindness has a very special place in criminal law. It is a state of mind that substitutes for actual knowledge. There are some crimes in which you have to know you're committing a crime in order for it to be a crime. It seems simple on paper, but when you get into some of the facts of the cases I want to show you, you're going to learn that it's not straightforward. Can you still be guilty of the crime even if you were suspicious of a certain element, but knowing is the crime, so therefore you just decline to conduct any further line of inquiry? In which case, the court will say that you were willfully blind, and we can use that as a substitute for actual knowledge of the crime. So I will give a couple of examples. First off, I just want to point out that the case we're going to look at deals with a crime of which consent was not obtained. So perhaps this is one for the little kids to skip if they happen to be watching. It's not going to take up a big part of this video, and this video itself is going to be quite short. But I just want to make sure that you're aware that this video may not be appropriate for kids. So we're going to start with the case of John Henry Sonnery Gray, or Sonnery Gray. I'm not entirely sure how to pronounce this name. It's actually an interesting name because I think it's French. This takes place in Manitoba, in Winnipeg, which has a lot of French speakers. But in French, sans just means no or nothing of. So sans regret just means no regrets. Now, as we're going to learn, the accused does have quite a few regrets in what happened in this case. So a quick summary of what's going on. Sans regret, or sans regret, however you want to say it, breaks into his ex-girlfriend's house and threatens her. To alleviate the situation, she gives consent to intercourse, which he follows through on. After he leaves, she then goes to the police and claims that she has been raped, which is just, I have to use grape to cover up the root word. Otherwise, YouTube will just censor it. So, the problem, though, is that she freely admits that she gave her consent to the accused, and he acted on the knowledge of that consent. So consent is a defense to a charge of sexual assault. The problem, though, is if you know that you have obtained that consent under the pretense of violence and threats, would you reasonably believe that consent is valid? And that was a question that the courts wrestled with. So in this case, the Supreme Court came to the decision that mistaken belief, yes, that is a defense. However, and the reason it is a defense is because you need a guilty mind in order to commit an offense. You have to have had some sort of knowledge of what you were doing was wrong and that it was going to lead to a bad outcome. So if you didn't have that requisite knowledge, then you're not guilty of a crime. Anyways, we can't look at the Section 143 because that's since been amended in our criminal code. We can have a quick look at the current version, right? So, where is that section? Oh, those are the punishments. Oh, yeah. So these are, the meaning of consent here. So Section 273.1, sub 1, or sorry, 273.1. Consent means for the purposes, and of course, these are the sexual assault offenses in the Canadian Criminal Code. A voluntary agreement to the complaint of the complainant to engage in the activity in question, right? And then these are all the exceptions. Consent is not obtained if it is expressed by the words and conduct of someone other than the complainant. So people can't consent on your behalf. And then, of course, the law was changed in order to codify this Supreme Court decision. And And so they added in the language that, if the accused belief arises from the accused's own self-induced intoxication, or if you were reckless or willfully blind to the validity of that consent, then it's not a defense. But before these changes were made, and you can actually see the citation right here is when this was all added into the criminal code. So the first change was added in 1992 and a subsequent change in 2018. This case is from 1985. So these provisions weren't in the criminal code then. And so the court had to kind of grapple with how to treat this case. This is a requisite part of the crime. You have to know that the person is consenting based on the threats or bodily harm, or reckless as to the nature of that consent. And that is where we come up with the term of willfully blind. An honest belief, even if unreasonably held, that a woman was consenting and voluntary, and not because of the threats, would negate the mens rea and entitle the accused to acquittal. Now, it's not a mistake of fact, and yeah, there was some there's some extra context too that this had happened previously, and the criminal route was not pursued in the previous incident, but of course this marked a dramatic escalation of the level of violence that he had displayed, and so he was arrested and charged in the second instance. So this is the sentence that this is the part of the paragraph that is central to what the court decided here. To proceed in such circumstances without further inquiry constitutes a self-deception to the point of willful blindness. Where the accused is deliberately ignorant as a result of blinding himself to the reality, the law presumes knowledge. So when you are deliberately ignorant and blinding yourself to reality, the law will assume that you have the requisite knowledge to commit the crime, the predicate crime. In this case, knowledge of the forced nature of consent, therefore there was no room for the application of the defense of mistaken belief. So they tried to, Sang Regret tried to say that he had mistake of belief that he had consent. However, his willful blindness negates that defense. Now, that is, of course, Canadian law. Let's jump on over to the concept of willful blindness in the United States. So these are jury instructions given. And of course, as much as I'm not a Canadian lawyer, I'm even less of an American lawyer. So I just happened to find this by Googling around, but they appear to be the instructions given by the court to juries defining certain elements. So the Ninth Circuit, which actually made the ruling that as we go down through the comments here, they made the ruling of which this rule is now applied. So their parlance is deliberate ignorance. And the instruction to the jury that a judge is supposed to give is, you may find that the defendant acted knowingly if you find beyond a reasonable doubt that the defendant, one, was aware of a high probability that, for example, drugs were in the defendant's automobile, and two, deliberately avoided learning the truth. You may not find such knowledge, however, if you find that the defendant actually believed there, for example, were no drugs in the defendant's automobile, or if you find the defendant was simply negligent, careless, or foolish. Now, those are important because negligence, carelessness, and foolishness are standards of guilt that are not typically applied to crimes. You have to have had actual knowledge or the intent of the outcomes. To simply be negligent, careless, or foolish would create criminals out of people who are just stupid, for lack of a better term. And that's not a standard we want in crime. You got to remember, being guilty of a crime is a standard above all other parts of law. It's not the balance of probability. It's not, is it more likely than not likely? It's not, are you kind of sure? No, you must be sure. You must prove beyond all reasonable doubt that a person committed the requisite actions and had the correct mental state to commit a crime. So being foolish or careless or negligent usually won't, there are exceptions, of course, but usually won't rise to that level of guilt to make you guilty of a crime. And in fact, we don't want to criminalize people who are not as smart as lawyers. Now, we're not talking about ignorance of the law. That's something entirely different. It's conduct and actions that you don't reasonably believe will lead to criminal conduct, right? For example, think of some of the pranks that you played as kids on each other, involving buckets of water, right? Um, think of any of the pranks that you played on each other as a kid. None of those are criminal acts, but there is a little bit of malice to them because it is a prank. And I'm not talking about the YouTube videos of, like, oh, let's act like an idiot in the hood. It's a prank, bro. It's just a prank. No. I mean, just innocent playfulness. And in the course of that innocent playfulness, someone gets hurt. Very common thing that happens. Well, that's not a crime. It's not an assault. It's not a battery. Because you didn't have the mental knowledge, the criminal intent to commit a crime. Now, there are situations in which you can take that same scenario and make it a crime. For example, using noxious substances in water balloons, like acid, and you are deliberately trying to hurt someone with that acid. I don't know if that's a good example. I think acid would actually eat through a balloon pretty quickly, but freezing paintballs would be another example of which you can cause some pretty serious damage. And you would, if you went in saying, I'm going to freeze these paintballs because I want to hurt that person, that is criminal conduct. But it's the intent that makes it a crime. You are intending the bad outcome. If you are just reckless, if you say, hey, I left the paintballs outside and it got really cold and they froze, and I loaded them and shot them and I didn't realize they were frozen, that's not a crime. Now, you can be civilly liable for the injury that you've caused. That's totally different. We're not going to throw you in jail in that scenario. So the comment here, this was the case that I guess led to the formation of this rule. But United States versus Heredia and United States versus Jewel, on which the language of this instruction is based. And in doing so, the court reiterated that in deciding to give a deliberate ignorance instruction along with an instruction on actual knowledge, the district court must determine whether a jury could rationally find willful blindness, even though it has rejected the government's evidence of actual knowledge. If so, the court may also give a Jewel instruction, which is, something different. Deliberate ignorance and instruction may be given in conspiracy cases. Deliberate ignorance is not the same as, deliberate ignorance is the parlance they're using for willful blindness. So if you actually read this decision, and I'm not going to bring it up, but, actually it's cited right here. Perfect. A deliberate ignorance or willful blindness instruction is only relevant if the jury rejects the government's evidence of actual knowledge. Okay, what does this mean? Where are you going to use this kind of deliberate ignorance? We're actually going to use it. So this is a case. This case is, R.V. Blondin. So this is a drug trafficking case. And in fact, this case cites another case too. So this paragraph here is what's going to be relevant. And this, of course, is the Beaver v. R.V. Beaver. which we learned, of course, in my criminal law class. But the important part is stated right here. In my view, the law is correctly stated in the following passage in the judgment of O'Halloran J.A., with whom Robertson J.A. concurred in R.V. Hess, 1948. So we're going way back into this legal concept. To constitute possession within the meaning of criminal law, it is my judgment that whereas here there is manual handling of a thing, it must be coexistent with knowledge of what that thing is. And both these elements must coexist with some act of control outside public duty. So public duty, of course, would be turning in something that is unlawful, otherwise unlawful to possess. So if you find a discarded gun laying on the sidewalk, it'd probably be negligent for you to just leave it there and not deal with it. I don't know. I wouldn't test that theory. Let's put it that way. Instead, you pick it up and you turn it into a police officer. It is not a crime in doing a public duty or a public service for the limited time that you're in possession of that illegal handgun. But you have to show that you were directly going to the police station and that you were going to turn it in within a very short window of time, because possession of an illegal handgun is a crime. Anyways, when those three elements exist together, I think it must be conceded, and there's a citation there, it does not matter if the thing was retained for an innocent purpose. So this passage is laying out what knowledge and possession, how they must coexist in order to be guilty of narcotic crimes, right? In this case, unlawful possession of a narcotic. So we have that foundation. But of course, knowledge was the key word in there. So what if you're handed a bag and you're told, don't look in the bag. It's none of your business. Take it over the border. You'll meet my friend on the other side and he'll take the bag from you. That is a situation in which you would be reasonably expected to conduct further inquiry. Okay, what's in the bag? What are you taking? Don't worry about it. And so you don't worry about it. Of course, you go across the border, the bag gets searched, there's a bunch of drugs inside. And you say, well, I didn't commit a crime. I didn't know what was inside. So the concept of willful blindness covers up that small little, I guess, loophole in the law where you can claim that because you didn't know there was drugs in the bag, you were highly suspicious of what was in the bag, but because you didn't actually look and you didn't know there was drugs, you're not guilty of a crime. And so willful blindness will step in and say, you should have made further inquiry. Your suspicion was aroused and you deliberately ignored any warning sign of what you were about to do was criminal in nature. And so you'll see that when it comes to consent in grape cases, as well as possession of narcotics, where the knowledge of the narcotic is central to the crime. In this, you could think of a case where you're holding on to a white powdery substance and you are told and reasonably believe that it's just a shipment of flour or powdered sugar. Of course, an officer tests it with the little, they have test kits, and it comes back as cocaine. You can actually be acquitted if you can demonstrate that you reasonably thought it was just a bag of flour. I'd never, I'm new at this job. I'd never handled flour before. It was in a bag marked flour. I was told it was flour. And I was just driving it to a place, to a bakery. I could see that you would get acquitted there. Remember, possession and knowledge must coexist with each other. So if you don't know it was cocaine, then you can't be charged with its possession. Willful blindness, though, says that there are circumstances in which a normal person would have had their suspicion aroused, and you deliberately chose not to pursue further inquiry, thinking that it would get you in trouble. So I hope that explained what willful blindness is. It's actually very rare that you see a legal concept that translates so well between the Canadian and US systems. And so I hope my American audience was able to appreciate what the Ninth Circuit did by creating their jury instruction of deliberate ignorance and how that translates to willful blindness in Canada. If you like this video, drop me a like. If you have questions, leave me a comment. I just wanted to add a quick note to the end of this video. I forgot to mention what the next topic I'm covering is. The next topic is going to be looking at what defines using your cell phone. And there's two court cases in Canada in which they have very different interpretations of what using your cell phone means. So we're going to have a quick look at that. We're also going to talk about the difference between criminal code offenses and provincial regulatory offenses. So look forward to that video. Till next time, everyone, stay frosty.